Welcome to episode 28 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name is Bailey, and I'll be reading the Supreme Court's opinion in GEO Group Inc. versus Menocal. The case was decided February 25th, 2026. And as always, we'll begin with the syllabus. Petitioner GEO Group operates a private detention facility in Aurora, Colorado, under a contract with U.S. Immigration and Customs Enforcement, ICE. Respondent Alejandro Menocal, a former detainee at the Aurora facility, initiated this class action alleging GEO's work policies for detainees violate a federal bar on forced labor and Colorado's prohibition on unjust enrichment. GEO responded that the suit must be dismissed under Yearsley v. W.A. Ross Construction Company, which held that a federal contractor cannot be held liable for conduct that the government has lawfully authorized and directed the contractor to perform. GEO argued that ICE had authorized and directed it to carry out the challenged labor policies, but the district court did not read GEO's contract with the government to instruct GEO to adopt those policies. The district court thus concluded that the Yearsley Doctrine did not relieve GEO of legal responsibility and a trial would be necessary. GEO immediately filed an appeal, which the Court of Appeals for the 10th Circuit dismissed for lack of jurisdiction, holding that an order denying Yearsley protection does not qualify for interlocutory review under Cohen v. Beneficial Industrial Loan Corporation. Held. Because Yearsley provides federal contractors a potential merits defense rather than an immunity from suit, a pretrial order denying Yearsley protection is not immediately appealable. Part A. The courts of appeals have jurisdiction over appeals from final decisions of the district courts. 28 U.S.C. Section 1291. A decision generally is final only when it resolves the entire case, when it ends the litigation on the merits or otherwise. That final judgment rule, by preventing piecemeal appeals, promotes the efficient administration of justice and preserves the proper balance between trial and appellate courts. Under the collateral order doctrine, however, a small class of decisions are treated as final and thus immediately appealable, even though they do not end a case. To get immediate review, a prejudgment order must satisfy three conditions this court has distilled from Cohen. The order must 1. Conclusively determine the disputed question, 2. Resolve an important issue completely separate from the merits of the action, and 3. Be effectively unreviewable on appeal from a final judgment. Whether the denial of a pretrial request to dismiss a case like the one here can satisfy Cohen's third condition will generally turn on whether the defendant has asserted a defense to liability or instead an immunity from suit. A party asserting a merits defense advances some reason why his conduct was not unlawful and he should not be found liable, but a party asserting an immunity need not challenge the merits of the charge against him. His claim of immunity does not turn on his conduct's legality. That difference entails another. Because it ensures a defendant need not answer for his conduct in court at all, an immunity is in its essence an entitlement not to stand trial. A liability defense, by contrast, does not allow the defendant to escape legal proceedings because it is through them that the asserted defense is addressed and liability finally determined. And that divergence matters for Cohen's third condition, which requires that the order involve a right that would be irretrievably lost absent an immediate appeal. The right not to stand trial is irretrievably lost once trial occurs, but the right to a finding of non-liability can be effectively vindicated after trial through reversal of an adverse final judgment. So if a defendant asserts a liability defense, Cohen is likely to block an immediate appeal. If he asserts an immunity, Cohen will likely allow it. Part B. Does Yearsley offer federal contractors a merits defense or instead an immunity? Menocal says a defense because Yearsley gives contractors only a way to show that their conduct complied with the law. GEO says an immunity, more specifically derivative sovereign immunity, where the government's own immunity extends to contractors who meet specified conditions. Yearsley provides a potential defense to liability, not an immunity from suit. In Yearsley, the courts held that a contractor that had flooded the Yearsley's property while performing work authorized and directed by the government was not liable to the landowner. The court explained that a contractor acting as an agent of the government could be held liable for injurious conduct in only two circumstances: when he exceeded his authority or when that authority was not validly conferred. The court found neither circumstance obtained in Yearsley because the contractor received a lawful authorization and stayed within the bounds of the authority given. That reasoning describes a defense, not an immunity. Yearsley's protection runs out when the contractor may have violated the law, when the contractor either acted under an illegal authorization or exceeded the scope of a legal one. Yearsley thus ensures that it will never shield unlawful conduct in the way that all immunities do. GEO's contrary view that it enjoys derivative sovereign immunity would put Yearsley in conflict with the general rule that sovereign immunity is not transferable to government agents. The court has repeatedly held that the government's immunity from suit does not extend to those that act in its name, including by reason of a contract with the government. The whole thrust of these decisions is to deny that government agents can assert, whether always or sometimes, a derived form of sovereign immunity. Instead, sovereign immunity belongs alone to the government. Part C. Once Yearsley is properly understood as a merits defense, the question before the court almost answers itself. Like the denial of other defenses, a district court's denial of Yearsley protection is not immediately appealable under Section 1291. Such a ruling is not, as Cohen's third condition demands, effectively unreviewable on appeal from final judgment. The right that a merits defense affords is to a finding of non-liability, and that right, unlike the right not to stand trial, is fully vindicable on appeal from a final judgment. Accordingly, the finality rule of Section 1291 precludes interlocutory appeal of a Yearsley denial. Justice Kagan delivered the opinion of the court in which Chief Justice Roberts and Justices Sotomayor, Gorsuch, Kavanaugh, Barrett, and Jackson joined, and in which Justice Thomas joined as to parts 1 and 3. In Yearsley v. W.A. Ross Construction Company, this court held that a federal contractor cannot be held liable for conduct that the government has lawfully authorized and directed the contractor to perform. Rather, liability may attach only if the authorization was unlawful or if the contractor acted outside its scope. The question here is whether a contractor may take an immediate appeal of a district court's pretrial order denying Yearsley protection. The answer is no. Because Yearsley provides a defense to liability, not an immunity from suit, an order denying its protection can be effectively reviewed after a final judgment. So appellate review of such an order, as of most pretrial rulings, must await completion of the district court's proceedings. Part 1. Petitioner GEO Group operates a private detention facility in Aurora, Colorado under a contract with U.S. Immigration and Customs Enforcement, ICE. The facility holds individuals whose immigration proceedings are pending. Respondent Alejandro Menocal was detained there in 2014. Soon afterward, he initiated this class action on behalf of the Aurora facility's detainees. The suit challenges two policies GEO used to put the detainees to work, thereby reducing its own labor costs. First, the so-called sanitation policy required detainees to clean, without any pay, all the facility's common areas. A detainee's failure to perform his assigned tasks led to escalating sanctions up to 72 hours in solitary confinement. Second, the so-called voluntary work program offered $1 per day to detainees for other kinds of needed work, such as preparing food and doing laundry. Menocal's complaint alleged that the former policy violated a federal bar on forced labor and that the latter breached Colorado's prohibition on unjust enrichment. Following discovery, the district court addressed GEO's contention that Yearsley required the suit's dismissal. That was so, the argument ran, because ICE had, by contract, authorized and directed GEO to carry out the two challenged policies. But the district court did not read the government contract that way. Nothing in its terms, the court found, instructed GEO to adopt the work rules at issue. Rather, in independently developing and implementing those rules, GEO far exceeded its contractual obligations. So the Yearsley Doctrine, the district court concluded, did not relieve GEO of legal responsibility. Instead, a trial would be necessary to address whether GEO's policies violated the referenced bans on forced labor or unjust enrichment. GEO immediately filed an appeal, but the Court of Appeals for the 10th Circuit dismissed it for lack of jurisdiction. Appellate jurisdiction, the court explained, seldom extends to an order that does not terminate the litigation at issue. Such an order qualifies for interlocutory review only if it satisfies 3 conditions deriving from this court's decision in Cohen v. Beneficial Industrial Loan Corporation, and an order denying Yearsley protection, the 10th Circuit held, does not do so. The court saw no need to address the first or third Cohen conditions because it concluded that a Yearsley denial flunked the second. Such a ruling is not, as Cohen demands, completely separate from the merits of the suit. That is because, the court reasoned, an inquiry into what the government instructed the contractor to do is relevant to both Yearsley's application and the lawfulness of the contractor's challenged actions. We granted certiorari to resolve whether a pretrial order denying Yearsley protection to a government contractor is immediately appealable. Like the 10th Circuit, we hold that it is not. But unlike the 10th Circuit, we focus on the third Cohen condition, which requires an order to be effectively unreviewable on appeal from final judgment. Part 2. Finality as a condition of review is an historic characteristic of federal appellate procedure. Originating in the First Judiciary Act of 1789, the finality requirement is now codified in 28 U.S.C. Section 1291. The courts of appeals that section provides have jurisdiction over appeals from final decisions of the district courts, and a decision generally is final under Section 1291 only when it resolves the entire case, when it ends the litigation on the merits or otherwise, and leaves nothing for the court to do but execute the judgment. That final judgment rule, by preventing piecemeal appeals, promotes the efficient administration of justice and preserves the proper balance between trial and appellate courts. For a small class of decisions, however, the finality rule gives ground and allows interlocutory appeals. Section 1291, we have often explained, requires a practical rather than a technical construction, and thus may treat as final certain decisions that do not end a case. We identify those decisions by category, not case-specific circumstances, and we erect a high bar. A non-terminal order may be appealed, Cohen held, only if it finally determines claims of right separable from and collateral to rights asserted in the action too important to be denied review and too independent of the cause itself to require that appellate consideration be deferred. That so-called collateral order doctrine we have since underscored is narrow, stringent, and of modest scope. To keep it that way, this court has distilled the Cohen ruling into 3 non-negotiable conditions. A pretrial order to get immediate review must 1. Conclusively determine the disputed question, 2. Resolve an important issue completely separate from the merits of the action, and 3. Be effectively unreviewable on appeal from a final judgment. Failure on any component of that 3-part test is fatal. When, as here, an order denies a pretrial request to dismiss, appealability under Cohen will generally turn on whether the defendant has asserted a defense to liability or instead an immunity from suit. If a defense, Cohen is likely to block an immediate appeal. If an immunity, Cohen will likely allow it. To show why, we describe below the difference between a merits defense and an immunity, what that difference entails for the right to avoid trial, and how that right matters in applying the third Cohen condition. Once that is done, it becomes clear why, as later described, the parties here mainly contest whether Yearsley offers an immunity or just a merits defense. Footnote 1. Note that one category of cases exists outside this dichotomy, a non-merits-based defense that also is not an immunity. On occasion, this court has decided that a defense, although barring suit irrespective of the merits, still fails to qualify as an immunity because it does not serve sufficiently weighty public objectives. That public interest wrinkle, however, never arises if the defense is on the merits, which, as we will explain, is the case here. Carrying on. To start, a party asserting a merits defense in a lawsuit makes a fundamentally different kind of argument than a party asserting an immunity. The former advances some reason why his conduct was not unlawful, or, said otherwise, why under the law he did nothing wrong. And so that defendant says he should not be found liable. Because he obeyed the law, he should not, for example, have to pay damages. By contrast, a party asserting an immunity makes no challenge to the merits of the charge against him. that defendant need never say that he followed the law because his claim of immunity does not turn on his conduct's legality, and immunity frees one who enjoys it from a lawsuit whether or not he acted wrongly. A classic example is sovereign immunity. It shields the government from suit absent a waiver, regardless whether the government violated the law. Footnote 2. Qualified immunity is, in the respect relevant here, the same. The doctrine shields a defendant even when the claim against him in fact has merit, or otherwise said, even when he violated the law, so long as the law at the time was not clearly established. Like other forms of immunity, then, qualified immunity offers protection even when the defendant acts unlawfully. Carrying on. That difference between a merits defense and an immunity entails another. The latter, but not the former, is in its essence an entitlement not to stand trial. Because an immunity applies irrespective of the merits, the protection it offers is not a simple finding of non-liability. Rather, the immunity ensures that the defendant need not answer for his conduct in court at all, that he avoids, in addition to liability, all the usual burdens of litigation, including a trial. And so we typically describe the protection in just that way, as an immunity from suit. A mere defense to liability, as we have noted, offers something different and of lesser value. Because it establishes that the defendant acted lawfully, a valid defense leads to a judgment of non-liability, but it does not allow the defendant to escape the varied rigors and costs of legal proceedings. Indeed, it is in and through those proceedings that the asserted defense is addressed and liability finally determined. And that divergence in whether the defendant possesses a right not to stand trial matters for the third Cohen condition. Again, that condition states that a non-terminal order may be appealed when issued only if it is effectively unreviewable on appeal from a final judgment. For that to be true, we have explained the order must involve a right that would be irretrievably lost absent an immediate appeal. The right to avoid trial fits that description. It is irretrievably lost once trial occurs, even supposing the defendant were to prevail on the merits, and so in the ordinary case, the denial of an immunity is immediately appealable. But the right to a finding of non-liability stands on a different footing. It can be effectively vindicated after a trial has occurred through the reversal of an adverse final judgment, and so the denial of a merits defense is generally appealable only once trial court proceedings have ended. In short, then, distinguishing between a merits defense and an immunity from suit in the way described above offers a ready way of determining whether the denial of a request to dismiss a case can satisfy Cohen's third condition for interlocutory review. Footnote 3. By the same token, that distinction is likely to determine whether the other two Cohen conditions are met, though we need not here address the reasons in any detail. Recall that Cohen's second condition, on which the Court of Appeals relied, demands that the order resolve an important issue completely separate from the merits of the action. A decision on a defense addressing the legality of the defendant's conduct goes directly to the suit's merits, whereas a decision on an immunity, applying regardless of that conduct's legality, does not. Similarly for the first condition, which is that the order conclusively determine the disputed question. When a defense turns on contested facts, as is often true, a pretrial order denying it functions only to defer its resolution until trial. By contrast, we have held, a pretrial denial of an immunity always acts as a fully consummated decision, because nothing can then happen to avert the trial the defendant maintains is barred. Carrying on. Part 3. For just that reason, the parties here mainly dispute whether our Yearsley decision offers federal contractors a merits defense or instead an immunity. Menocal, supported by the United States as amicus curiae, says a defense because Yearsley gives contractors only a way to show that their conduct complied with the law. GEO says an immunity, more specifically derivative sovereign immunity. GEO contends the government's own immunity extends to contractors who meet specified conditions, thereby giving them the right not to stand trial. So which is it, a defense or an immunity? Yearsley involved a suit by landowners against a federal contractor for flooding their property. The government had hired the contractor to redirect the Missouri River in order to improve its navigation. The construction company, as specified in the contract, built dikes in a part of the river near where the Yearsleys owned a farm. The result, as expected, was to wash away almost 100 acres of their land. The Yearsleys did not dispute that the contractor's work was all authorized and directed by the government. Nonetheless, they sued the contractor for money damages. The court held that there was no liability on the part of the contractor. Drawing from multiple precedents involving agency law, the court explained that a contractor acting as an agent of the government could be held liable for injurious conduct in only two circumstances: when he exceeded his authority or when that authority was not validly conferred. Here, neither circumstance obtained. As to the second, the court explained that the government had validly authorized the company to flood the Yearsleys' land because the government itself possessed that legal right and had properly delegated it by contract. And as to the first, the court concluded that all the company's work had stayed within the bounds of the authority given. The government had provided instructions and the contractor had merely executed its will. Given both these facts, the government's lawful authorization and the contractor's compliance with it, the court could see no ground for holding the contractor liable. That reasoning describes a defense, not an immunity. Yearsley provides protection to a contractor when it has received a lawful authorization and acted according to its terms, meaning when the contractor has acted within legal bounds. So in invoking Yearsley, the contractor is making the argument of a merits defense, that it is not liable because it has complied with the law. Conversely, Yearsley's protection runs out when the contractor may have violated the law, when the contractor either acted under an illegal authorization or exceeded the scope of a legal one. By drawing the line there, Yearsley ensures that it will never shield unlawful conduct in the way that all immunities do. In short, because Yearsley protects a contractor only when, and only because, it has acted lawfully, Yearsley operates as a defense to liability on the merits, and that is consistent with all Yearsley's language. The decision never refers to an immunity or otherwise suggests that the defendant receives a pass from legal proceedings. It asks only whether the contractor may be found liable. Still more, GEO's contrary view would put Yearsley in conflict with the general rule that sovereign immunity is not transferable to agents, including contractors, of a government. As Justice Holmes once explained, the federal government's immunity from a suit, absent a statute providing otherwise, does not extend to those that act in its name. The court repeated that precept in the term just before Yearsley. The government does not become the conduit of its immunity in suits against its agents just because they do the government's work. Rather, the exceptional freedom from legal responsibility that sovereign immunity offers is confined to the sovereign entity itself. Or again, a few terms after Yearsley, a private contractor cannot obtain immunity from suit by reason of a contract it made with the government. GEO tries to bypass those rulings by arguing that they preclude a contractor from asserting only unconditional sovereign immunity, not the supposed derivative sovereign immunity Yearsley offers, which is conditioned on compliance with the government's lawful directives. But the proposed distinction is strained. The whole thrust of the decisions is to deny that government agents can assert, whether always or sometimes, a derived form of sovereign immunity. Rather, the court insisted sovereign immunity belongs alone to the government. And another pre-Yearsley decision proves the point, by relegating a state agent that had asserted sovereign immunity to a merits defense whose contours anticipated what Yearsley would offer. Oddly enough, the suit challenged the same kind of conduct involved in Yearsley. The government agent had flooded a person's land. The state itself, the court noted, would have had immunity from a suit based on such conduct. But an agent working on the state's behalf could not avail itself of that special exemption from judicial process. Immunity from suit, the court explained, is a high attribute of sovereignty, a prerogative of the state itself, which cannot be invoked by the state's agents. Yet all was not lost. The agent got something. Although the agent was not exempt from suit, it could successfully defend against the charges by showing the lawful authority under which it acted. Those terms evoke the ones Yearsley used later, and they function not, as GEO posits, to condition the transfer of sovereign immunity, but to describe something different, as the court made explicit, a merits defense. Footnote 4. GEO counters that two of our decisions refer to Yearsley as offering immunity, but that argument makes far too much of one piece of loose language. The first cited case, Brady v. Roosevelt S.S. Co., mainly cuts against GEO. As noted above, the court there rejected the view that a government contractor obtains immunity from suit by virtue of its contractual relation. The court then turned to Yearsley, finding it not to apply because the suit alleged negligent conduct outside what the government had authorized. In that half paragraph, the decision once refers to Yearsley as providing a certain immunity, but it apparently used that term in a colloquial sense as something of a synonym for protection. The court's fuller description of Yearsley explains that it relieves the contractor of liability without suggesting that it also offers a pass from litigation. And the second cited case, Campbell-Ewald Co. v. Gomez, gives GEO even less to work with. That decision merely quotes the imprecise phrase in Brady on the way to rejecting another contractor's claim, even more expansive than GEO's, to share in the government's sovereign immunity. Carrying on. Once Yearsley is understood in that way, as a merits defense, the question before us almost answers itself. No, a district court's denial of Yearsley protection is not immediately appealable under Section 1291. Like the denial of other defenses, such a ruling is not, as Cohen's third condition demands, effectively unreviewable on appeal from a final judgment. The right that a merits defense affords is to a finding of non-liability, and that right, unlike the right not to stand trial, is fully vindicable on appeal from a final judgment. All an appellate court need to do at that point is reverse the erroneous liability finding, so the finality rule of Section 1291 precludes interlocutory review of a Yearsley denial. Footnote 5. This holding still allows review of a given Yearsley denial by means of Section 1292B's separate appeal certification process. Under that provision, a district court may find that the special difficulty and importance of an otherwise unappealable order counsels in favor of immediate review, and an appellate court may accept that determination. Here, though, the district court saw no reason to act under Section 1292B. Carrying on. For those reasons, we hold that the Court of Appeals lacked jurisdiction over GEO's appeal. If eventually found liable, GEO may, of course, appeal the district court's rejection of its asserted Yearsley defense, but GEO must wait until then. A Yearsley denial is not appealable before the trial court's proceedings have ended. We therefore affirm the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Thomas concurring in part and concurring in the judgment. I concur in parts 1 and 3 of the court's opinion and in its judgment. I agree with the court that Yearsley v. W.A. Ross Construction Co. and similar decisions establish a defense from liability and not an immunity from suit. Orders rejecting Yearsley defenses are therefore unlike the orders denying immunities that this court has already held to be immediately appealable. Because no other statute or rule authorized an interlocutory appeal here, the court correctly affirms the Tenth Circuit's dismissal. I do not join Part 2 because we need not, and in my view should not, further justify our holding by applying the collateral order doctrine established by Cohen v. Beneficial Industrial Loan Corporation. I remain of the view that we should not expand the Cohen collateral order doctrine beyond orders that our precedents have already held to be immediately appealable. The Cohen collateral order doctrine, which allows federal courts to exercise appellate jurisdiction over certain interlocutory orders, conflicts with Congress's authority over federal appellate jurisdiction. By statute, parties generally cannot appeal before final judgment. Congress has established certain exceptions to that final judgment rule that allow parties to appeal some interlocutory orders immediately. It has also authorized this court to create further exceptions through rulemaking. Cohen's collateral order doctrine allows judges to create additional exceptions by judicial opinion, which bypasses Congress's delegation of the rulemaking process as the way to define or refine when a district court ruling is final and when an interlocutory order is appealable. For that reason, if an interlocutory order is not on all fours with orders we previously have held to be appealable under the collateral order doctrine, it should not be immediately appealable. Justice Alito concurring in the judgment. I agree with the court that the defense conferred by Yearsley v. W.A. Ross Construction Co. is not an immunity from suit. I therefore agree that an order denying a Yearsley defense is not a collateral order subject to immediate appeal. But I would not rest these conclusions solely on the fact that Yearsley's applicability turns on the defendant's conduct's legality. Under the collateral order doctrine, defendants may sometimes appeal the denial of a defense immediately when doing so is necessary to vindicate important constitutional or public policy interests, and this rule holds true even if the defense at issue turns on the legality of the defendant's conduct. Thus, I cannot join the opinion of the court, but I concur in the judgment because deferring appellate review of Yearsley rulings until final judgment does not imperil important constitutional or public policy interests. Part 1. Since 1798, Congress has generally limited the universe of appealable orders to final decrees and judgments. Today, this final judgment rule limits the jurisdiction of federal courts of appeals. The court has long given this limit a practical rather than a technical construction. Consistent with that approach, our decision in Cohen held that certain interlocutory orders, now known as collateral orders, are sufficiently final that a party may appeal them before litigation reaches final judgment. Our collateral order doctrine establishes 3 criteria that an order must satisfy to qualify for immediate appeal. The order must 1. Conclusively determine a disputed question, 2. Resolve an issue separate from the merits of the action, and 3. Be effectively unreviewable on appeal from final judgment. Whether a given order satisfies these criteria does not turn on the facts of a particular case. Rather, the criteria must be satisfied for the entire category of orders. Section A. Initially, this court applied the effectively unreviewable requirement to capture orders that would become moot by the time of final judgment. For those orders, a strict application of the final judgment rule would practically defeat the right to any review at all. We first applied this reasoning in Cohen, which involved a district court order that excused the plaintiffs from a litigation bond requirement. Applicable state law required the plaintiffs to post such a bond to secure their obligation to pay the defendant's litigation expenses and attorney's fees if their claims failed. Cohen held that the order excusing the plaintiffs from posting that bond was immediately appealable because it would not be merged in final judgment. Regardless of who prevailed at final judgment, the question whether the plaintiffs had to post a bond would be moot. If the defendant prevailed, an appeal would not relieve it from the plaintiff's failure to post a bond. And if the plaintiffs prevailed, the defendant would not be entitled to recover its legal costs. Thus, if orders denying requests for litigation bonds were not subject to immediate appeal, those orders would never receive appellate review. This conception of the collateral order doctrine's effectively unreviewable requirement informed our decision in Swift & Company Packers versus Compañía Colombiana del Caribe, S.A. There, we held that the Fifth Circuit had appellate jurisdiction over a lower court's order vacating the attachment of a foreign vessel. That vessel, which the libelants attached while it passed through U.S.-controlled waters, served as security for their claims against the foreign defendant. In this respect, the vessel resembled the bond in Cohen. As was the case with the bond order, an immediate appeal was the only means for appellate review of the order vacating the attachment of the vessel. If the libelants in Swift did not prevail at final judgment, the court's vacatur of the attachment order would become moot. And if the libelants did prevail, any appellate review of the attachment issue would be an empty right, as the vessel would have likely departed U.S. jurisdiction. The same reasoning explains our jurisdictional holding in Stack v. Boyle, which extended Cohen to an order denying a criminal defendant's motion to modify his pretrial bail bond amount. Once a court renders final judgment in a criminal case, the conditions governing the defendant's pretrial release become moot. By that juncture, the defendant has either been released from custody or begun a sentence of incarceration. Thus, if there were to be any appellate review of bail, it would need to occur before final judgment. In sum, our early collateral order cases applied the effectively unreviewable requirement narrowly. It captured those orders that would be unreviewable on appeal from a final judgment on account of mootness. Section B. Over the ensuing decades, the court expanded its application of the effectively unreviewable requirement to include orders that undoubtedly would not become moot by final judgment. For example, in Abney v. United States and Helstosky v. Mener, the court held that denials of defenses under the Double Jeopardy Clause and Speech or Debate Clause satisfied Cohen even though these protections could be vindicated on an appeal following final judgment. Like most criminal law defenses, double jeopardy and speech or debate issues merge into the final judgment, and a reviewing court can grant meaningful relief on these grounds by reversing a defendant's conviction. Abney and Helstosky nevertheless held that denials of relief under these two clauses were collateral orders. Our holdings in these cases relied on the premise that those two protections were not merely shields from criminal liability. They were instead guarantees against being put to trial at all. Thus, although a court could review these defenses on appeal from a final judgment, a court could not fully vindicate their protections at that time. By the time of final judgment, the defendant would have already been exposed to trial, therefore suffering the very harm that these defenses exist to prevent. This line of reasoning sufficed to render the orders in Abney and Helstosky effectively unreviewable on appeal from a final judgment. This doctrinal development had important implications for our collateral order jurisprudence. Under Abney and Helstosky's logic, once a court designates a defense as an immunity from suit, that defense satisfies the third collateral order criterion. We have likewise recognized that an order denying an immunity from suit will also satisfy the other two collateral order requirements. The denial of an immunity satisfies the first criterion because it conclusively determines that a defendant may go to trial. And a claim of immunity is conceptually distinct from the merits, so an order denying an immunity claim satisfies the second requirement. For these reasons, federal courts have consistently held that denials of an immunity are collateral orders subject to immediate appeal. Given that the designation of a defense as an immunity is dispositive under the collateral order doctrine, our court has stringently guarded the designation. After all, virtually every right that could be enforced appropriately by pretrial dismissal could be loosely described as an immunity from suit, but treating every such right as an immunity would permit the narrow collateral order doctrine to swallow the final judgment rule in virtually every case. Our court has therefore recognized the need to distinguish between a right not to be tried and a right whose remedy requires the dismissal of charges. And we have explained that determining whether a defense constitutes an immunity requires an evaluation of the value of the interests that an immediate appeal would advance. Specifically, we explained in Will v. Halleck that a defense should be treated as an immunity demanding the protection of a collateral order appeal only if wrongly allowing a suit to proceed would imperil a substantial public interest. Our collateral order decisions reflect this approach. We have applied the immunity label to defenses when allowing an immediate appeal was necessary to preserve some particular value of a high order, such as honoring the separation of powers, preserving the efficiency of government and the initiative of its officials, respecting a state's dignitary interests, and mitigating the government's advantage over individual defendants in high-stakes matters. In contrast, we have declined to designate defenses as immunities when postponing appellate review to final judgment would not imperil important interests. As these decisions illustrate, we have been cautious in recent years about expanding the collateral order doctrine, but we have not closed the book on Cohen. Just 2 terms ago, we designated another defense as an immunity and evaluated it in an interlocutory posture. The test for determining whether a defense constitutes an immunity therefore remains keyed to the interest that an immediate appeal would vindicate. If postponing review of a wrongly denied defense would undermine important constitutional or policy interests, that defense constitutes an immunity. Part 2. Under this framework, the Yearsley Doctrine is not an immunity from suit. Permitting immediate appeals of orders denying Yearsley defenses is not necessary to vindicate any sufficiently important constitutional or public policy interests. Section A. As the majority correctly explains, Yearsley shields defendants from damages actions for conduct that federal law authorized. Although this protection is important for a range of government operations, it does not meet the threshold to be designated an immunity. First, postponing appellate review of Yearsley's applicability until final judgment would not create significant separation of powers problems. To be sure, the possibility that courts might impose liability for conduct that Congress authorized prevents some conflict between those two branches of government. Likewise, incorrect contractor liability adjudications can interfere with executive branch operations. But these risks of error arise any time a court misapplies a federal statute or entertains an action involving a government contractor. Moreover, these risks pale in comparison to the separation of powers concerns that motivated the application of the collateral order doctrine in other immunity contexts. Yearsley does not implicate sovereign dignity interests either. Although GEO Group describes Yearsley as conferring derivative sovereign immunity on contractors, this label is a poor fit. Sovereign immunity protects governments from the indignity of being subject to a court's jurisdiction. We have never described the Yearsley doctrine in those terms, nor have we suggested that it limits courts' jurisdictions over contractors. Rather, Yearsley merely shields contractors from exposure for conduct that federal law authorized. I therefore agree with the majority that the Yearsley doctrine derives from the government's lawmaking authority, not its sovereign immunity. Last, unlike with qualified immunity, allowing immediate appeals of Yearsley denials is not necessary to prevent overdeterrence, timidity, and distraction in government service. That is not to say that these concerns are entirely absent when plaintiffs bring damages actions against government contractors. As this court recognized in Filarski v. Delia, the public has an interest in preventing overdeterrence, timidity, and distraction in government functions no matter the nature of the defendant's particular relationship with the government. But our doctrine already accommodates these concerns by allowing contractors to invoke qualified immunity. Indeed, qualified immunity provides a greater protection to contractors than Yearsley does, whereas Yearsley shields only those contractors who act within the bounds of their legal authorization. Qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. And as the defense's name indicates, contractors may immediately appeal denials of qualified immunity. Because qualified immunity already vindicates the public interest in avoiding overdeterrence, timidity, and distraction among contractors, there is no overriding interest in also allowing immediate appeals of orders denying Yearsley's more modest protections. Footnote 1. Although government contractors may generally assert qualified immunity, this court has held that private prison guards may not in 42 U.S.C. Section 1983 cases. Separately, this court has not decided whether corporate contractor defendants like GEO Group may invoke qualified immunity. Perhaps the public interest would be well served by allowing appeals of orders denying Yearsley defenses to those defendants who cannot invoke qualified immunity. Even so, our doctrine requires us to decide whether Yearsley denials are collateral orders as a category, not as applied to particular defendants. If, however, most defendants who invoke Yearsley could not invoke qualified immunity, the collateral order analysis might be different. For example, if corporate contractors could never invoke qualified immunity, then there would be a stronger argument that denials of Yearsley defenses would be immediately appealable. Carrying on. In sum, allowing immediate appeals of orders denying Yearsley defenses is not necessary to vindicate any important constitutional or public policy interests. Accordingly, the Yearsley doctrine is not an immunity from suit. And because Yearsley issues can be reviewed on an appeal from a final judgment, these orders do not otherwise satisfy the third collateral order requirement. Section B. Rather than conducting the public interest inquiry that our immunity case law employs, the majority trains most of its analysis on a single question: whether the Yearsley doctrine turns on the defendant's conduct's legality. Because the Yearsley doctrine does, the majority concludes that it fails to satisfy the third collateral order requirement. That analysis is oversimplified. Of course, whether a defense turns on the legality of a defendant's conduct can be relevant to the collateral order analysis. For example, the degree of overlap between a defense and a defendant's conduct can bear on whether an order is separate from the merits of the action. It is also true that certain immunities from suit are jurisdictional bars that shield a defendant from judicial process regardless of whether it acted lawfully. Nonetheless, the majority's rule cannot fully explain our collateral order case law. For instance, qualified immunity is an immunity from suit, yet its applicability can and often does turn on whether a defendant violated the law. Indeed, before this court decided Pearson v. Callahan, a court evaluating a qualified immunity defense had to resolve the illegality of the defendant's alleged conduct. We nevertheless treated and continue to treat denials of qualified immunity as collateral orders. On the other side of the ledger, we have held that several defenses are not immunities even though they do not turn on the legality of the defendant's conduct. For instance, this court has held that neither the Federal Tort Claims Act's judgment bar nor a criminal defendant's right against vindictive prosecution qualifies as an immunity from suit, even though neither defense concerns a defendant's challenged conduct. In short, although the majority's focus, whether a defense turns on the legality of the defendant's conduct, can be relevant in the collateral order analysis, it is not dispositive of whether a defense constitutes an immunity. Because postponing appellate review of Yearsley issues until final judgment would not imperil important constitutional or public policy interests, I concur in the judgment of the court. And that is it for the opinions in this case. Once again, unanimous Supreme Court decision, at least in the judgment. There's a little bit of disagreement, I guess, in how they get to that judgment. With Thomas not joining us to part 2, I think Alito didn't join the opinion at all, but concurred in the judgment and got to the same outcome by different reasoning. But yeah, by statute, the appellate courts have jurisdiction to review final orders of the district courts. The Supreme Court has read that, more pragmatically and said, okay, well, certain things that aren't quite final judgments can be immediately appealed if it satisfies these conditions. Yeah, and so the question is, okay, well, is a Yearsley defense or immunity or whatever, is it one of those? And the court says, no, the Yearsley establishes a defense from liability, not an immunity from suit. And because it's a defense from liability, it doesn't satisfy these conditions in order to be immediately appealable, so it's not immediately appealable. And I guess Justice Alito somewhat disagrees with the majority's reasoning, as to how it gets there. Justice Thomas joins some of the reasoning, but not other parts. It was kind of interesting reading the majority's opinion and getting the statutory and jurisprudential sort of source of these, of this concept, of this doctrine. I kind of suspected that Thomas's concurrence was going to be concerned with the statutory and jurisprudential source of this of this whole doctrine. And happily I was kind of right. I've I guess read enough Thomas concurrences and dissents and whatnot to sort of at least in a lot of cases, not in all of them, but in a lot of cases, like, be able to predict if Thomas is authoring a lone opinion or dissent, kind of what he's going to be talking about, because he likes to, where he disagrees with like some more fundamental part of the case, like where all of this is coming from, something that maybe they don't have to address in that case, but some doctrinal issue that he has, he's definitely one to like bring that up where other justices might not. And he says, hey, this whole like Cohen, doctrine, or this doctrine stemming from Cohen is in conflict with the statute. Like, we're admittedly not reading the statute for what it says. And the majority like explicitly says this. This isn't like, this isn't like contested that we're really not reading the statute for what it says here. And so I was kind of expecting Thomas to be like, yeah, we should revisit that and like just undo this doctrine because we're not reading the statute for what it says. He doesn't go quite that far. He says we just shouldn't extend this doctrine because this doctrine allows courts to make exceptions to the finality requirement for immediate appeals in manners that Congress has not authorized. And he says, okay, so we shouldn't extend this if if it's not on all fours with things that we have held to be immediately appealable in the past, we just shouldn't let them be immediately appealable. We need to cabin this as much as possible because it's just inconsistent with the statute. And so he doesn't join part 2 just because part 2 is the court applying this this doctrine from Cohen, and he's like, nope, we just shouldn't be applying that doctrine anymore because, if we're applying that doctrine, there's a chance we expand that doctrine. No, we should just say this isn't on all fours with stuff that we've previously held to be immediately appealable. It's not immediately appealable. Done. Over. Nothing more. And I'm sympathetic to that. As I was reading the majority's opinion, I get to this point where the majority points out like, oh yeah, the court has read this statute in a more, pragmatic way. I don't remember what specific phrase the court uses, but, says, oh, we haven't read this, strictly, we haven't read this, just for what it says. We've read it in a more pragmatic sense and established this whole doctrine around it. And I'm like, that just I don't like that. I tend to prefer more textualist, originalist approaches. And I mean, when the court is straight up just admitting we're not reading the statute strictly for what it says, yeah, that's not textualism. That's not originalism. That just strikes me as the court making things up out of thin air, and the court's not supposed to make things up out of thin air. I don't like when the court makes things up out of thin air. Judge created doctrines that just come from nowhere, that are plainly and admittedly inconsistent with the statute's text. I think those are not okay. Those are not. It's almost a usurpation of the judiciary's role. So I'm kind of sympathetic to Justice Thomas in this, which hey, as listeners may have gathered by now, not uncommon. I tend to like a lot of Justice Thomas's lone concurrences and dissents. At the very least, they tend to be interesting. So, and then, I don't know, Alito's concurrence, I'm not really the biggest fan of because it's like, I don't know, it's focused on this like standard of, oh, well, how do we determine whether something's a defense or an immunity? And the way that we determine that, Alito says, is if it implicates like sufficiently important public policy or constitutional concerns, then it might be an immunity, and if it doesn't, then it might be a defense. And it's like, that just strikes me as an insanely squishy standard, and I much prefer the majority's, Alito claims, oversimplified analysis of, hey, does this go to the merits of the claim? Does it immunize unlawful conduct or not? If it immunizes unlawful conduct, then it's an immunity. If it doesn't, and if it applies conditional on the legality of the defendant's conduct, then it's a defense. That seems like a much more straightforward standard to me, a standard that is much more grounded in the law and less in judicial policymaking to me. I don't like judicial policymaking, and it's a little disturbing to see Alito, defending a standard that feels a lot like judicial policymaking. But I guess he comes to the same conclusion as the rest of the court. I think the correct conclusion, so whatever. And since the court did make some passing remarks about qualified immunity and immediate appealability of denials of qualified immunity and whatnot, I guess I'll just make a passing remark of my own that I don't like qualified immunity. And I certainly don't like that denials of qualified immunity are immediately appealable. Just for practical reasons, I think the legal basis of qualified immunity, especially qualified immunity for Section 1983 claims, is dubious at best. But assuming qualified immunity is a thing, the legal basis for immediate appealability of denials of qualified immunity, that might be sound. But just for practical reasons, I hate qualified immunity so much. But that is a tangent for another day. So, with that, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue on through the Supreme Court's 2025 term. Until then.